Mr. Alvendia?
Yes, Your Honor.
All right, sir.
Good afternoon, Your Honors, and may it please the court. My name is Rico Alvendia, and I represent the appellants in this matter. I'll be arguing on behalf of all three of the appellants, Roosevelt Collins, Khoury Payne, as well as Jerome Davis. Your Honor, the appellants respectfully request that this honorable court reverse a district court's holding and find that the appellants are entitled to relief under Rule 60B of the Federal Rules of Civil Procedure because the appellee had actual notice that the appellants were injured at sea when they were working on the maritime vessel, the Atlantic Grace. Your Honor, the appellants also request that this court reverse the district court's finding that the Rule 60B action was filed untimely, because in fact it was filed within 1 year of the final limitation judgment. Your Honor, just a brief facts of what happened here. It was February 16, 2016. The three appellants were working for a temp service called Savard. They were working at the direction of BIS services on the Atlantic Grace ship. They were in a cargo hold. They were cleaning out the concrete, and then there was an elision. The maritime vessel, Miss Sylvia, ran into the vessel. Immediately after the accident, as they climbed out of the cargo hold, the appellants notified their employer, BIS, who was directing them that day, that they were injured. That brings me to my first point, Your Honor, which is the appellees in this case had actual notice that the seamen were injured.
What's your best case saying that knowledge of an injury is all that's required as opposed to knowledge of a claim?
And that's exactly where we get to the Eastern District Court case, Your Honor, that Judge Barbier ruled on Global Industries Offshore. That's cited as 2000 Westlaw 1610384, Eastern District. Judge Barbier, in considering a Rule 60B action, said this: I'm not going to let you open this action back up. I'm not going to let the plaintiff do it. And specifically, he said this: the plaintiff's argument that he was entitled to actual notice of the proceeding, as to Hockley's argument, that he was entitled to actual notice of the proceeding, nothing in the record suggests that Global was aware of his injuries. That Global was aware of his injuries until he filed the state court act after the limitation proceeding had already terminated. He goes on to say, given the dilatory nature of Hockley's claim and absence of anything to suggest bad faith on the part of Global. That's important, Your Honors, because Judge Barbier is essentially saying the defendant did not know that he was injured, not that he didn't make a claim. Now, it's important to distinguish that from what the appellee has argued in this case. We know that at the two depositions of the BIS employees, the appellee asked the witness, do you know who Jerome Davis is? Do you know who Roosevelt Collins is? Those are the appellants. Your Honors, they asked that question 9 months before the final judgment dismissing the limitation action. So that begs the question, well, wait, where did they get these names from? Why were they asking about the appellants 9 months before the final limitation action judgment? This might shed some light. There was a workers' comp case filed a year before those depositions in February 2017. And the plaintiffs in that case were Roosevelt Collins, Jerome Davis, and Khoury Payne.
Yeah, but who was the employer for purposes of that workers' comp claim?
BIS Services, Your Honor, and it's a good question. BIS Services was a party to that limitation action. Louisiana Workers' Compensation was a party to the limitation action. At the deposition I just referenced earlier, Counsel for Workers' Comp was there.
But maybe that means the fact they're going after their employer for workers' comp means they're not going after the ship. Right? I mean, why?
Your Honor,
you could read it the opposite way. They're just going to go after their workers' comp.
Absolutely agree with that, Your Honor. You could look at it from that angle as well. But the reality is, I think when we're looking at this case, Judge, we need to ask the question, we respectfully submit this court ask this question: what is the purpose of notice in a limitation action? The ship is availing itself of limiting its exposure to the value of the ship. You might have hundreds of people are hurt. They're taking advantage of that process. So the due process balance says you have to give notice to those who might have an interest there. And you know, in our case, this is interesting because the appellee, when asked the same question by Judge Malazzo of District Court, she concluded in oral argument, she said, I think it's clear you had notice that Jerome Davis and Roosevelt Collins were injured. And she said that, at page 15 of the record, of the transcript of oral argument at page 2631 of the record, she said, I think it's clear from these depositions I've been talking about, you had noticed that someone was injured, these two appellants. The question she had, which was the correct question, is, do you then have an obligation to give actual notice to an injured person, an injured seaman? Now, the appellee responded with two cases. They said, Orion Dredging, get that site. They said Orion Dredging, a middle district court out of Florida, says you don't have to give actual notice to an injured person, a possible claimant. Only someone that you know has filed a claim. But what's interesting is they cite to the Fifth Circuit case of In re River City. And when you pull In re River City, nowhere in that Fifth Circuit case does it set this bright line rule.
Do the supplemental admiralty rules help us answer this question? Do the supplemental rules in the FRCP help us answer this question that Judge Costa asked at the beginning? What is more relevant, notice of the injury or notice of the claim made by an injured person?
And that's the seminal question we're addressing.
Right, but do the rules, do the admiralty rules speak to this?
It does not.
No?
It does not have a situation where the ship owner actually had notice of the injury of an injured plaintiff. That's a difference here. It says, the rule says, mail notice to known claimants. And
Well, maybe I'm reading the wrong rule, but F4?
Yes.
Okay. As I read it, it says, the ship owner is obliged to, quote, mail a copy of the notice to every person known to have made any claim against the vessel or the plaintiff, arising out of the voyage or trip on which the claim sought to be limited arose. Is that the right rule?
It's the right rule, Your Honor. However, and that's why he asked, Judge Costa asked earlier, is there a case that supports your position here? And we cite to the only case in the Fifth Circuit jurisdiction that even mentions Rule 60B in the context of misconduct, which we're alleging here. And this is the case by Judge Barbier that says, look, understand Rule F, but in this case, I'd like to help you claim it, but you have not shown that the ship owner knew that you were injured. Didn't say knew that you made a claim, said knew that you were injured. It's a very important distinction, Your Honors. And I'll tell you that in the In re River City case, which the appellee says it's well-settled law, it's crystal clear that Fifth Circuit says you don't have to give actual notice if you know of an injured seaman. Again, nowhere in that opinion does it say that. What it does cite to actually is Mullane versus Central Hanover Bank. It's a U.S. Supreme Court case on due process, 339 U.S. 306. And I'll just cite it quickly from Mullane, which In re River City talks about. The fundamental requisite of due process of law is the opportunity to be heard. This right to be heard has little reality or worth unless one is informed of the matter. You can't get to where your day in court if you're not informed of that notice. That's where we go back to the balancing here, judges. Your Honors, we're asking for the Fifth Circuit today to say, if you have a seaman that you know is injured, you have to take practical measures.
Are your clients seamen or are they longshoremen?
Well, Your Honor, and they are longshoremen, but I'll say plaintiffs are working on the vessel. That's what we're talking about here. Yes, that's essentially what I'm referring to.
I mean, one of the real serious points of contention, assuming your complaint is timely or is 60B, is exactly what was testified to. And the GATX says the Brumfield just said that no more than the fact that he thought he recognized the names and of these people, and they may have stated that they were injured, but he never specifically stated that Jerome Davis was injured. Now, it doesn't say Collins. And Jeremy Pino said he didn't know of anybody other than the original 3 claimants, or 4, who told him they were injured. Now, who's accurate and who's not accurate?
Well, Judge, and I think we need to take a look straight at the depositions. Page 21 of Mr. Brumfield's deposition, that's at page 2258 of the record. Once again, the appellee, not the witnesses, bring up the names Jerome Davis and Roosevelt Collins. He starts inquiring, what were they doing on the ship? Were they the temp workers? He is filling in the blanks for the witness in that deposition.
Now, is this deposition the same as, this is not the compensation proceeding that you're talking about then, is that correct?
I'm sorry, Your Honor.
The Brumfield deposition. Yes. Was that taken for the limitation proceeding or the compensation proceeding?
Your Honor, it was actually, we obtained those depositions on the eve of the first proceeding when we were trying to open the limitation action. The district court did not consider it. The district court was only presented, and if I were to receive it from plaintiff counsel.
I don't think you're asking, was the deposition my understanding is it was part of in the limitation proceeding. She's not where it's considered. Where was it taken? If you look at the deposition, what case was it taken in?
But we did not obtain it. These depositions were taken for other plaintiffs. It wasn't for us. We happened to want these depositions. But to answer your first question, Your Honor, it says after appellee filled in the blanks that Jerome Davis and Roosevelt Collins were the 2 temp workers in the cargo hold, at page 27 of the deposition, to wrap it up, appellee asks, did anyone else in the cargo hold, number 1, say that they were hurt when they got up to the top? He said yes. The BIS employee says yes. He says, okay, who was that? Everybody but Tim. He already filled in the blanks for him that Jerome Davis or Roosevelt Collins was in the cargo hold. He says everybody but Tim. And then appellee asked, wait, everybody but the temps? He said, no, but Tim. Tim is the only one who wasn't injured. Your Honors, I think that's why it's important to take a look at what Judge Malazzo says in the record. Again, at page 15 of her oral transcript, she says, let me ask this question, though. I did read the oral argument from the last time. I think it's pretty clear that there was notice at least of February 20, 2018, that engineer Jerome Davis and Roosevelt Collins were injured. And again, she asks the germane question after that. I guess the question is, what's your obligation once you're on actual notice that somebody has been injured in a limitation action? That's when appellee states, well, there's case law that's crystal clear in the Fifth Circuit. As long as you don't have notice that they made a claim, you don't have to tell them anything. No notice, there's no, that just flies in the face of.
But time for notice, I mean, those depositions, if I'm looking at them correctly, did happen before the entry of whichever judgment is the final one. But they did happen after the entry of default and after the time period for sending notice. So how do you deal with that?
It did, Your Honor. And that's, look, we're confined within that time constraints. I can't tell you that we don't wish we had got a hold of those depositions before.
Sure, no,
but here's the question you need to ask, Judge. If there was a Louisiana workers' compensation lawyer present at the deposition, how hard would it have been for appellee to say, Roosevelt Collins and Jerome Davis, do they have a claim for injury here? They did. They filed it a year before the deposition.
How about if Roosevelt Collins and Jerome Davis asked their lawyers, don't we have another claim?
Well, Your Honor, and again, I wasn't counsel at the time, but I know for a fact that counsel had made a workers' comp claim, and he was aware of the 3-year limitation, statute of limitations. He was not aware of the limitation act.
Maybe that counsel, I mean, that's, most folks know these limitations proceedings get filed if there's potential maritime claims.
Your Honor, and I understand that, but the peculiar thing there is that he was dealing with the workers' comp attorney for over a year, and he was not told there was a limitation action going on. So again, not to parse out who did, he should have done this, should have done that. The reality is this. If you look at even the district court's statement in oral argument, she concluded that there was notice of an injury. And that's why we state that there's an abuse of discretion. And look, abuse of discretion as defined by the Fifth Circuit in Kennedy versus Texas Utilities is a misapplication of the law or misapplication, an erroneous assessment of the evidence. And when she asked that question about was there a rule, she was given this case law that said it's relied upon a Fifth Circuit case. You pull a Fifth Circuit case, it doesn't say that. There is no rule there is no rule that states if a ship owner learns that one of its workers were injured, all they have to do is publish it in a newspaper. You know, I'll close my argument with saying this, Judge, and I'll reserve the rest for rebuttal.
All right.
Just want to get to Mullane here.
Well, no, Mullane.
So, Ron?
Your time's up for your principal argument.
Okay.
Thank you.
Okay, thank you.
All right,
Thank you, Your Honor.
that's okay. Mr. Khoury.
Good morning, Your Honors, and may it please the court. The substance of this case involves only one single issue, whether my clients, the limitation petitioners, and the appellees gave proper notice of a limitation action. Two prior panels of this court have already determined that proper notice by publication was given to the appellants here. Appellants now claim that new evidence in the form of deposition testimony taken in a limitation action, as I think Your Honor pointed out, 8 to 9 months after a default order had been entered, shows that they should have received personalized notice mailed to them personally. As the district court in this case held, the evidence that they submit in this hearing is neither new nor compelling. In fact, the appellants were in possession of this same deposition testimony at the time of the first set of hearings in the district court, which was subsequently affirmed by two separate panels of this court. It appears that the panel is interested in the substance more than the first two arguments on timeliness and standing, so I'm going to
I'm interested in timeliness also.
Okay. Well, I'll start there and then I'll head to the substance. So let me start with the standing issue, which is, I guess, where you usually start. The question is,
if you're going to start with standing, I have a question about that, which is whether it's forfeited, because I think it's you acknowledge you didn't raise it below. Your response is, well, it's standing, so it's jurisdictional. Certainly as to Article 3 standing, you're right. But there, all you require for an injury is just some harm, and I think certainly not having your claim considered, your personal injury claim considered is an Article 3 injury. So it seems to me it's more you're arguing under the terms of the rule, we're not a party. It's more like a statutory standing. It's really a rule standing. But so that normally would not be jurisdictional in the sense that you can't waive it. So why don't you respond to that and tell me why it is before us.
Yeah, so Your Honor, and I actually just happened to look up this case this weekend. It's a United States Supreme Court case, Horn versus Flores. It's at 557 U.S. 433, when the court addressed the issue of standing in the context of a Rule 60B motion. I believe it was a Rule 60B-5.
What year is that case?
I'm sorry?
The year of that case?
2009, and it's Horn v. Flores. So I think that, and specifically the court said in that case, it mentioned Article 3 standing right after it mentioned Rule 60B. So I think the import from the court was that they do consider Rule 60, the ability to have standing to file a Rule 60B motion as caught up within the case or controversy requirement of Article 3 necessary to have standing. And we admittedly acknowledge that we did not raise this issue before the district court, but as the Fifth Circuit has repeatedly held, and I just have one site in particular, Sierra Club Lone Star Chapter versus Cedar Point Oil, because standing is jurisdictional, it may always be addressed for the first time on appeal.
So let me ask you about the implications of that. I'm not talking about this case. There's a case where there's actually the injured seaman has a case on file in state court, filed a claim against the vessel owner. And the vessel owner files a limitations action, and there's a known lawsuit out there, but the vessel owner doesn't provide notice of the limitation proceeding to that plaintiff in a pending state court suit. The limitation action wraps up. It's clear misconduct there, clear violation of the court order to provide notice. And you're saying, well, too bad, that plaintiff in state court who filed a claim can't can't follow Rule 60 because it wasn't a party to the limitations action.
Your Honor, I think in that scenario, they would be considered a party to the limitation action without having actually filed a claim, because as part of a limitation proceeding, and this is dictated by Admiralty Rule F4, when there is a known claim, you are obliged to mail notice to that. And in some districts, I think it's actually the clerk of court who will mail notice. In the Eastern District, the parties are allowed to mail notice and file an affidavit.
But that's their argument here. I mean, they might be wrong, but that's their argument here, is that we satisfy that requirement. You should have provided notice to us.
Well, they're saying that they satisfied it based on a deposition. They're saying they should have received notice based on deposition testimony after a default order by someone who was in no way affiliated with my client's ship or their companies. They told somebody else that they were injured. And then that trickled down and came down later in a deposition that we learned.
Right, that's why you don't think it actually was a claim, but you're acknowledging someone can be a party even if they didn't appear in the limitation proceeding, if they should have been sent notice, basically. And then 6 months later, they say, oh my God,
Yeah, I think there's circumstances where someone could be, for purposes of Rule 60, considered a party to that, even though they didn't file a formal claim under the circumstances you mentioned, because they were required to receive notice, and they actually did file a claim. There's no dispute in this case that no claim was ever filed by the appellants until after both orders dismissing this case. There's no dispute. They don't even claim that they ever made a claim prior to the case being dismissed with two orders. And I guess that sort of segues into my...
So, just to finish the loop on that, you would say as a result, no standing to bring the Rule 60 motion, therefore?
Correct.
Is that right? Okay.
So the second issue that I'll address is the timeliness issue. And the issue is, for purposes of bringing so the appellants have asserted right to relief under 60B subsections 1, 3, and 6. The sections 1 and 3 have a 1-year time limit from the operative order. Section 6 has no such time limit, but this court has held that whenever the grounds for relief is encompassed within sections 1 through 3, you can't then rely on section 6 to circumvent the 1-year time limit. So what we're dealing with here is the 1-year time limit. Appellants contend that this time began to run from the district court's order of November 26th. Our position is that it began to run from a prior order of dismissal on September 8th of 2018. They respond that it's not the September date that's the operative order, because that was a conditional order rather than a final order. And we believe the case, the Fifth Circuit case of Newball versus Offshore Logistics is applicable here. Like the conditional order in Newball, any conditions contained within the district court's order here served as conditions subsequent to the dismissal, not conditions precedent to the dismissal. Specifically, the district court's order in September of 2018 here stated, this action is hereby dismissed as to all parties without prejudice to the right upon good cause shown within 60 days to reopen the action if settlement isn't consummated. The very reference I would submit to reopening the case means that the case is in fact closed and that the dismissal was presently effective. Furthermore, the settlement was in fact consummated on November 7th of 2018. The settlement agreements were put into the record before the district court within that 60-day time period. So as of November 7th, 2018, it wasn't even possible to reopen the limitation action. other than some extraordinary means by Rule 60. But as of the date that the settlement agreements were effectuated, there was no way to reopen based on the court's original order, and that order became effective as of the date that it was entered. Now, appellants argue that Newball is limited to conditional forum nonconvenience dismissals because that case involved that, and this is simply an incorrect assertion. The only mention of Newball in the case that they cite, which is Lopez Dominguez, was in a footnote. And in that footnote, the court indicated that the reasoning of Newball with respect to the distinct issue of whether conditional dismissal orders were considered final for purposes of immediate appeal seemed particularly applicable in the forum nonconvenience context. However, nowhere in the Lopez Dominguez opinion or in the footnote was Newball restricted to forum nonconvenience cases. But more importantly, the Lopez Dominguez decision certainly didn't restrict Newball's reasoning with respect to the separate issue of whether a particular conditional order of dismissal is final for purposes of triggering the one-year period under Rule 60B, because Lopez Dominguez didn't even involve a question of the timeliness of a Rule 60B motion. Lastly, I'm going to transfer to the sort of what I call the substance of the appeal. As I mentioned earlier, setting aside the procedural issues, the substance of this appeal centers around whether we gave proper notice of the limitation action. The appellants repeatedly state that they did not receive notice, which is contradicted by the two prior panels, which explain that proper notice by publication was given. Judge Duncan, you asked a question of appellant's counsel about what the rule says as to whether you have to give written notice directly sent by mail to someone who you know is injured, or do you have to give that notice to someone who has actually made a claim? And I think you read from the rule itself, but I think it's important emphasizing that it says that the notice shall be published in such newspapers as the court may direct once a week for 4 successive weeks prior to the date fixed for the filing of claims. The plaintiff, not later than the day of second publication, shall also mail a copy of the notice to every person known to have made any claim against the vessel or the plaintiff arising out of the voyage or trip on which the claim sought to be limited arose. I think that answers the question here, is that it's not whether someone had notice of an injury, it's whether there had been a claim made against the vessel or the plaintiff, which in this case is the limitation petitioner. And the answer to that is indisputably no, as they even acknowledge. No claim was made until both orders of dismissal by the district court.
Does a claim have to be something filed in court, or could it be a demand letter?
It could be a demand letter. And that kind of dovetails with another kind of issue in the Limitation Act. There's an issue in the Limitation Act of when someone has to, you have 6 months from knowing that a claim has been asserted against your vessel to file a Limitation Act. And the Fifth Circuit and many other circuits have held that notice of a claim can be a letter from an attorney saying, we are going to assert a claim against you, and that starts the 6-month period. And I think actually to make things consistent, it should be the same here. And I'll just point out that the notice of the injury here, they make reference to the fact that they file workers' compensation claims, that they told BIS. But I think, and I know your honors are aware of this, but I think it just bears repeating that those are parties that are in no way connected to my client or their vessel. These are separate parties, separate proceedings. They mentioned that LWCC, who was the workers' comp carrier that they filed a complaint against, was a party to the limitation action, but they were only a party to the limitation action because they asserted a right to recoup benefits that they paid to the original 4 claimants who did file timely claims. They didn't file a claim in the limitation action and never said anything about, oh yeah, these other guys have also asserted a comp claim. They didn't seek to, if they were going to seek recoupment of what benefits they paid to them, they certainly didn't assert it in the limitation action. So our position is that if a claim had been made, then yes, notice should have been sent personally, individualized, but that's not what happened here. It was something that occurred during a deposition where counsel, myself, learned from a witness, and the characterization of the testimony, I think Judge Jones pointed to, is important as well. But even if we assume that the sum total of these witnesses, which takes inference upon inference because they referred to them not by their names, by the temp guys. But even if you get past all that and assume that inference upon inference told you that these individuals had sustained some type of unspecified injury on the ship, the outcome of this case doesn't change. The requirement is still that you publish notice, you give notice by publication to anyone who is a potential claimant, possible claimant, and you mail notice to anyone who was known to have made a claim. And that's what we did with the individuals who were part of the limitation action who did file claims. We mailed notice to them, and their attorney filed a claim in the limitation action. One thing I think that is important to note from the appellant's briefs is that they repeatedly refer to themselves and their claims as potential claims. I think that's a very crucial point because as we mentioned in the case we cited, Orion, which relied on this court's decision in Ray River Cities, that was part of the issue there, is that the court held that potential claimants are not entitled to mailed notice. Potential claimants are entitled to notice by publication. As a practical matter, the ship that was hit that the appellants were on was a huge cargo ship, hundreds likely of people on that ship. The limitation action simply doesn't require you to track down everyone on that ship and then mail them notice of a limitation action because they are potential claimants. They may have been injured, but the law requires you to mail notice to those who you know to have made a claim. Anyone who you know to be injured or something less, someone who is a potential claimant, the law requires notice by publication. And I think that's important to note within the confines of a Rule 60B motion, because what they have argued, the primary argument is under Rule 60B-3, I believe it is, which is that we committed fraud or misconduct. I would submit to the court that that's quite a bold statement to say that we committed fraud or misconduct when we followed the letter of the law to a T. We followed Supplemental Admiralty Rule F4 exactly as it's written and is exactly the way that it was intended to be followed. And so I think it's a tall order to show that that would constitute fraud or misconduct on behalf of our client. And unless the panel has any more questions, I think I'm...
No, sir, thank you very much.
Thank you.
May I proceed, Your Honor?
Yes, sir.
I'll take up where Appellee left off. Look, we don't use these, appellants, believe me, do not use these words lightly, but the only definition of what misconduct or may be under Rule 60B-3 is found in the one case that Appellee has stayed away from. Didn't mention it here, didn't mention it in their brief, didn't mention it to the district court. The only case that talks about misconduct in this context is Global Industries Offshore, where Judge Barbier says, had you shown that the owner of the ship knew you were injured, not knew that you made a claim, knew that you were injured, then you would maybe have relief under Rule 60B. That's his words. They have nothing to contradict this case. They haven't even they haven't even touched it. in their brief. I didn't think they would touch it up here. The other thing that
What
they
case
wanted...
do you have granting Rule 60 relief in this type of context?
We don't have that, Your Honor. This is a unique situation where we have depositions that were given, they gave actual notice. And look, it's not my words. Again, the district court concluded, reading the depositions, they had actual notice of Jerome Davis and Roosevelt Collins being hurt, injured on the ship. We're not talking about 300 people on the ship that are making a claim here. We're talking about 2 people, the appellants, that the appellee knew about. Listen, the other thing that hasn't been explained is, why did they ask the names at the deposition? Why did the appellee bring up Jerome Davis and Roosevelt Collins?
Aren't they listed as witnesses?
And I'm glad you brought that up, Your Honor. In the Rule 26 disclosures, you have close to 15 people. I believe it's 14 people listed as witnesses. The only 2 people that the appellee brought up were Jerome Davis and Roosevelt Collins?
But we held that the fact that they were listed as witnesses was insufficient to say that they were claimants.
Absolutely, Your Honor, but now on top of that, we have the deposition testimony. That's what's new in the context of the Rule 60B action. It's the deposition testimony completes it. There's no, and look, again, I'll point the court's attention to page 2631 of the record, where Judge Malazzo concludes that Jerome Davis and Roosevelt Collins, they had noticed they were injured. And I think the court gets it. What we're really asking the court respectfully to do here is to do the same thing that in Ray Rivers City, the Fifth Circuit case, which they cite to as a bright line rule, saying you don't have to give injured people, if you know about them, notice, actual notice. It cited to Mullane and said, Mullane addressed situations where a party might seek to provide potential claimants with constructive notice, where actual notice was impossible or impractical. How was it impossible or impractical here for an appellee to say, Louisiana Workers' Compensation attorney, who's at the desk? Did Jerome Davis and Roosevelt Collins make a claim? Were they injured? Yes, they would have got the answer. And guess what? 3 more weeks went by before the second deposition, where the Louisiana Workers' Compensation lawyer was present again. Appellee brought up Jerome Davis and Roosevelt Collins' names up again and asked the witness, were they injured? Were they the temp workers? Yes, yes. Where did they get these names from? Why were they so interested in these 2 claimants? These 2 people who were working on a ship, because they were injured. They didn't make a workers' comp claim. I'll leave you with this, Your Honors.
The entire value of the vessel, I think it was $500,000. Has that already been distributed, the whole limited amount?
And that's a great point, Your Honor. We get the prejudice in this case. There's been no affidavit submitted by the appellee that the funds were exhausted in this case.
But what if they were? How would this work? I mean, that'd be, you take money back from people who've already spent?
No, let me say this, Your Honor. In that situation, that would go towards prejudice. Now you're infringing on their limitation action or protections given. But they are supposed to, by letter of law, submit an affidavit saying, we have exhausted all of our funds. They didn't do that. Okay, they didn't do that with 4 claimants. They didn't say it did.
Well, let me ask you another question that's pertinent here. What about the untimeliness?
Yes, Your Honor, and it gets back to what Judge Costa was asking. This is really almost a circular argument when you say, look, number one, you didn't have standing in the limitation action because you weren't a party to it. Well, they weren't a party to it because they had no notice of it. They had no notice. As far as the filing within 1 year of a final judgment, we can go round and round on Newball. Newball was a forum nonconvenience case. There was only 1 judgment in that case, which was a final judgment. In this case, there were 2 final judgments. One was a preliminary dismissal. The second was November 26, 2018. There's no question in this case, we filed within 1 year of the final decision in the limitation action, which was November of 2018. Judge, in closing, if I may just state, this U.S. Supreme Court stated in the Mullane case, where they were trying to rely on publishing in a newspaper when they knew of potential plaintiffs in that case, it said, it would be idle to pretend that publication alone, as prescribed here, is a reliable means of acquainting interested parties of the fact that their rights are before the courts. Chance alone brings the attention of even a local resident to an advertisement. And what the Supreme Court was saying is, you got to protect the due process rights of people like the appellants here. If you know they're injured, and it's practical, and it's easy to find out where to find them, you gotta make some effort. No effort was done here other than publishing in a newspaper, which the counsel at the time did not see.
All right, sir.
Thank you, Your Honor.
Thank you. Court is in recess until 1 o'clock tomorrow afternoon.